Good morning. We're going to go ahead and get started. Thank you for coming to the SBS 6th Annual Research Conference. Today we have a presentation by Cynthia Renteria, but first I would like to introduce our provost, Avidan Rodriguez. If he can come forward and tell us a little bit about our speaker.
Thank you, and welcome everybody. It's my distinct pleasure today to introduce our speaker for this morning. It's still morning, isn't it? Yes, well, still morning. Cynthia Renteria. And Cynthia Renteria is a partner of the law firm of Perez Renteria here in Edinburgh, Texas. She's admitted to practice law with the State Bar of Texas and the United States District Court in the Southern District of Texas. In addition, Ms. Renteria is a current member of the American Immigration Lawyers Association and a member of the Hidalgo County Bar Association. Ms. Renteria has focused her practice on immigration and nationality law. She and her office have assisted clients with their family-based immigrant petitions, consular processing cases, naturalizations, residency renewals, and waivers. In addition, Ms. Renteria currently represents clients in removal proceedings before the Executive Office of Immigration Review in Harlingen and Port Isabel here in Texas, and has handled issues before the Administrative Appeals Office and the Board of Immigration Appeals. She also focuses her practice on employment-based visa petitions and non-immigrant-based investors' visas. Ms. Renteria is an experienced immigration practitioner whose law firm consists of staff who are committed to providing quality immigration services. Ms. Renteria is a graduate of Our Lady of the Lake University, we won't hold that against her, and St. Mary's University School of Law. Ms. Renteria's presentation will focus on the impact of criminal cases and on immigration cases. Please help me welcome Ms. Renteria. Thank you so much.
Okay, I don't know. I think he has my presentation. I don't have it. Oh, there it is. Great. Good morning, everybody. So what I wanted to do is, I know the title of the piece is Criminal Issues Affecting the Immigration Status, but I kind of wanted to begin by giving you a rundown of what exactly it takes to become a legal resident of the United States. I think right now the environment is a little hostile towards people who don't have legal documents, and there's a misconception that they just don't want to make the effort, they want the public benefits. And what I wanted to do by starting off the presentation is give you an idea of how can somebody immigrate into the United States. It's not enough that you say, I have a good job in Mexico, I have money in my bank, can I get a permit to live in the United States? It's not that easy. It's much more complicated, and so I kind of wanted to give you an idea in the beginning, how can you get your residency? So obtaining lawful residency. There's family-based petitions and there's employment-based petitions. The great deal of what I see in my office is family-based petitions. And so the immediate category is the quickest way, presumably, but it still takes some time. And the immediate is a United States citizen petitioning for their spouse, their parent, or their child, under 21. In the state of Texas, 18 and under is a child for purposes of immigration, 21 and under is a child, but you have to be single. If somebody comes into my office and says, I'm a United States citizen, I want a petition for my husband, how can I do it? My first question is, how did this person enter the United States? If they say, they entered legally, they entered with a visa, second question, have they ever had any problems with immigration? No problems with immigration. Third question, any problems with the law? No problems with the law. Great, this is an easy case, so to say. 4 months is what it's taking, and our office here is in Harlingen. So all of the Valley goes to Harlingen for their interviews, for immigration interviews. This is an easy case. If the client comes in and says, I want a petition for my spouse, they entered illegally, they've already been removed, they came back again, then that person is not going to be able to immigrate, even though they're married to an American, because they came in illegally, they stayed illegally, they left, whether of their own volition or because immigration detained them and sent them back, and they came back illegally. So they've got multiple violations, and even though they're married to a United States citizen, They may have citizen children. That does not help them. What we tell them is you got to wait for the law to change, and be careful. So even when you're married to an American, it's not as clear cut because we need to do a clear search of what the history is, what the violations have been, to see if you're eligible or not. The first preference is a citizen petitioning for a child over the age of 21. And this takes about 18 years. So you come in right now and you say, I'm a United States citizen, I want to petition for my daughter who's 22 years old. She's going to wait 18 years. You get in line right now in 2012, and right now it takes 18 years before you're able to even get your residency. And they'll say, okay, well, this person going to get a permit, any sort of permission, they get nothing. And if they're in the United States, they're in the United States illegally. So in the course of these 18 years, if they get detained, then they're facing removal back to Mexico, even though their parent is a United States citizen. Our first question after we get past our aggravation is, why didn't you ever file for them before? Procrastination with immigration is not your friend. And so, you've got wait times, you've got delays, you've got age requirements, and so you waiting till next month, next year, till I have the money, it has to be a priority. Because even though you say I'm an American, my child's 21 now, it's going to take a long time. So what if we have residents? Resident comes in, I'm an LPR, I became a resident during the amnesty in the 80s, I want a petition for my wife and kids. This person became a resident in the early 90s, and they're coming in right now to ask, how do I do this? It takes about 2.5 years, and they've got to go through Juarez. And when they go through Juarez, more often than not, they have a punishment for living in the United States without papers. They're going to have to ask for a waiver, which they have to wait out in Juarez for. The resident comes in and says, I want a petition for my child. He's 21 years old. That right now is taking about 19 to 20 years before they're able to do it. So you get in line right now and you wait your turn, and it takes about 19 to 20 years before you're able to do anything with it. United States citizen petitioning for a child who's married. The benefit when you're a citizen is you can immigrate your married son or daughter, their wife or husband, and their kids. So you can get them all in. The problem is it takes 18 years to do it. And so a lot of people are like, well, forget it, it's going to take 18 years. Well, 18 years is going to pass whether you file the petition or whether you don't. So file it, and in 18 years you can decide whether or not you want to actually come and immigrate or you don't. Fourth preference, U.S. citizen sister or brother petitioning for another sister brother. I'm a United States citizen, my brother's in Mexico, I want to bring him over. 16 years. So, these are people who have the relative willing to immigrate them, willing to petition for them, willing to sponsor them, but there's a backlog. And we can't do anything with that. It is what it is. They take the time that they take, and the reason is that there's only a certain amount of visas released every year for every specific category, and there's more applicants than visas available. So, and I apologize for this because I pulled it from the Department of State website. But to give you an idea of what it's taking, the Family First Preference, which is a United States citizen petitioning for a child over 21. From Mexico, there are currently over 90,000 people waiting, just for Mexico. The other oversubscribed countries are the Philippines, the Dominican Republic, and Jamaica. In all, U.S. citizens petitioning for children over 21 throughout the world, there are 295,000 people waiting, just in that category. The F2A, which is the residents. Resident petitioning for spouse or children under 21 from Mexico, over 138,000 people waiting for that right now. Throughout the world, over 322,000. And this is a separate category. And these are people that have the ability to immigrate, but there's just nothing available for them right now. This one is the F2B, we call them F2Bs, resident petitioning for a child over 21. And the child has to stay single. A resident cannot petition for a married child. And so, the problem is it takes 18 to 20 years to do it. And in the course of that time, these kids grow up. They become adults, they fall in love, they want to get married, well, they can't. And so it's a very fine line because we'll have clients whose children live with their girlfriend. They have children with their girlfriend, but they're not married. And Texas is a common law state, meaning you do not have to go to the court or to a judge to get married. If you live together as husband and wife, if you commingle your assets, and if you represent each other as husband and wife, then you're considered married under the law. That's common law. And so, our clients have to walk a very fine line because you can't be married. And so, we make sure that they don't file any sort of tax returns as husband and wife, because that's a federal document showing, I'm a husband and I'm a wife. Because in order to get the benefit, you cannot do that. I had a client once who, waits 18 years for his appointment. We talked to him before. We told him, you're not married. You've got no, marriage certificate. Do you represent her as your wife? No. Do you have things in both your names? No. Do you live together? Yeah. Do you have kids together? Yes. But we're not husband and wife. We went over it. We went over it. We went over it. We go to the interview. The officer asks, well, do you ever introduce her as your wife? Yeah. With that, it was over. He didn't get it. Just because he very nonchalant, matter of fact, said, yeah, sometimes I do. It was enough for the officer to say you no longer qualify for the benefit because your father's a resident and he cannot petition for a married son. And that was it. After 18, 19 years. So it's very harsh with that, and you have to be careful because, these people want to live their lives. They want to have a normal life. And telling them, oh, you can't get married even though you want to and you fall in love, it's difficult. And sometimes they're willing to lose the option of being able to immigrate legally because they choose instead to have a family. The family third preference is a citizen petitioning for a married son or daughter. And that's the benefit of having a citizen parent, because a citizen parent can immigrate everybody. They can immigrate married, single, does not matter. That one is over 180,000 people waiting. We're seeing more of this one right now because of the violence in Mexico. And so people come into our office and they're United States citizens. They were born here, never lived here. Born here, stayed here a while, went to Mexico, and they've lived a great life in Mexico. With the violence that's happening in Mexico, they're looking for the way out. And so we have mothers coming in with their adult children, all educated, wealthy, living well over there, but because of the violence, they're looking for the way to get out. And so they come in saying, well, my mom's a citizen, is there any way that I can get her citizenship? Well, unless your parent has lived here for a certain number of years prior to your birth, you cannot just get the citizenship. They don't give that to you. There's requirements under the law. There's physical presence that we have to establish on the part of the parent. And so it's not a given that just because, my mom's an American, you're going to get it. And in most cases, we can't do that. So then we're like, okay, well, let's immigrate you. It's not acceptable to them that it takes so long, 18 years, because they need something now. And we can't do anything now. And these are people who didn't foresee what's happening in Mexico happening. And so they didn't do anything. They weren't proactive about, well, let me go get a residency, because they were perfectly fine and content in Mexico. And now that the circumstances have changed, they're looking for ways out, and we really can't help them, not in an immediate fashion. So it's when we start looking for other options. You have a degree. Is there an employment-based visa that we can maybe get you? Is there an investor visa that we could get you? And we explore other options. But, that's not the great majority of applicants. Not everybody coming out of Mexico. And I say Mexico because, geographically speaking, it's what we see more. But not everybody coming out of Mexico qualifies for these types of visas. The fourth preference is, brother petitioning for brother, sister or sister, siblings. And that one, there's over 746,000 people waiting right now. And so, what do? You wait. Now, a lot of these people, they want to do it right. We have clients, I don't want to violate the law. I want to make sure everything's done correctly. We filed the petition right now. It's called the I-130 petition. We file it right now. Your place in line is in 2012, April 12, 2012. That's your place in line. Right now, they're working, 16 years back. The problem is that these people have visas to come and visit the United States. It's, it used to be the tarjeta local, visa láser. It's a B1, B2 visa. That's the name of the visa. And so they're allowed to come visit, can't stay for more than 30 days. They go back, and they're fine. They're carrying on. They visit their family in the United States. When we file a petition, then it's an immigrant petition. And the visa they have is a non-immigrant visa. The B1, B2 visa does not allow them to live in the United States. They cannot have the intent to immigrate with that visa. So when we file an immigrant petition and this person goes up for renewal of their tourist visa, it's going to come up. And the consulate's going to say, well, we're not going to give you your visa again because you don't want to go visit, you want to go live. Your brother filed for you in 2012, and they won't issue them the visa. It's a bit nonsensical because even if they remain in Mexico, they can still immigrate through Ciudad Juarez, which is where all of Mexico goes for family-based petitions. But the U.S. consulates abroad, and here it's Matamoros, will say, no, we're not going to issue you the visa. And so people have to weigh what's more important to them. Do I want the chance to have a legal residency in the United States? And many times that they decide to do that, it's because of their children, and run the risk of not being able to travel and visit anymore, even though I've never violated the law, simply because I filed a petition, or do I just not file the petition and continue with my B1, B2? And it's a heavy burden on them because we cannot guarantee that they'll be able to renew that tourist visa. But we also can't guarantee that they won't. And so it's the uncertainty that is difficult for clients when they're having to make, an informed decision. So the employment-based visas are another way of obtaining the residency. And these, we see them, but not quite as frequently. There were some changes with H-1Bs, and so it used to be that, there was a mass exodus to apply for these H-1B visas, and then when the economic crisis happened, they placed restrictions, and so, things were not the way they were before. An EB-1 is the extraordinary ability, outstanding professors, and the multinational executives. These visas, they're current. If you get a petition on an EB-1, then you don't have to wait in line. You go to the front of the line. We see these with we had one who's a Mexican, she's a singer out of Mexico. She's pretty famous, files a petition under an EB-1 with all her glory, and they get her approved, and she goes to the front of the line. The professors, we have medical doctors that also qualify for an EB-1. They go to the front of the line. Multinational executive, this one comes out with the L-1 visa. You work in Mexico as an executive or a manager, and you transfer to a U.S. company, or you work in any country as an executive or manager, and you transfer to a U.S. company, a subsidiary, an affiliate, you qualify for an EB-1 as a multinational executive. The EB-2 are the advanced degree professionals. These could be some of your PhD applicants, some of your master's applicants. I-140 petitions, they're also current. The EB-3 is the one that's backlogged. It's taking about 6 years, and these are your H-1B applicants, your bachelor's degrees. Somebody comes in on H-1B, has a bachelor's degree in engineering, the employer files a petition, it takes about 6 years. And these people have to go and renew year after year after year, and most often they have to go to their consulates to do that, and some of them get frustrated. I've taken clients to Matamoros who are renewing their H-1B visa because they've got a pending I-140 under the EB-3 category, and they get frustrated. You're going on EB-3. 6 years seems like not very long when you look at the grand scheme of things, but these are professionals, and they're like, forget this, I'm just gonna go back to my country and go work over there. I've been renewing this thing for 7 years. There's a sense of frustration with them. When they talk about reform, these are the groups of people that they kind of wanna expedite. They wanna open up more visas for these people because, the presumption is that we want these educated individuals who are, at the top of their game in the United States. We don't wanna lose them. The EB-4 are the special immigrants. It's also current. We don't see very many of them. And the EB-5 are the investors. This is the one that everybody's talking about right now. There's some backlash because they're buying their residency. They're buying their residency. The EB-5 requires at a minimum of $500,000 investment, and you have to generate 10 U.S. citizen employees. It's a conditional residence for only a 2-year period, and after the 2-year period, you apply to remove the condition. Our office does not handle this one. My law partner is Leonel Perez, and he's handled it in the past. I have a client right now. We actually just had a meeting with him 2 days ago. He's an EB-5. He filed in 1997. The visa's been around, since 94, I think. But it wasn't really utilized. So he files 97, 98. He gets the conditional 2-year residency. We file to remove the condition, and they don't want to remove it. And they said, we lost your file, we refile. We don't know where the file is at. We don't know what service center has it. He has been pending for 11 years. And they will not tell him why they don't want to remove the condition. So he's on 1-year extensions, him and his family. At this point, it's 11 years down the line. His son is 27, his daughter's 23. If we say, you know what, let's just file a new one, then they're out. So we have to preserve the one that we've already filed. He's frustrated because his company makes $9 million a year, has 80 employees, and immigration won't adjudicate his removal application. So, we're on the brink right now is, do we have to go under federal court on this? What are we gonna do? He's one of 2 applicants that we have like that, And it's a visa that we've just decided not to do. It's extremely complicated, and right now, because it's being publicized so much more now because of the violence in Mexico, people are looking for the way out and they want residency. Immigration is getting very strict on them. You need to show where the source of funds are at, and you need to show that the money comes legal. You know, business people in Mexico are like business people in the United States. You don't necessarily want to show all your assets, you know, and you know, they have ways that, you know, they hide assets, and, you know, maybe the books don't reflect where, you know, how much money there actually is. And if you can't establish that, then we're going to have issues with the EB-5. Right now in the Valley, I don't really know of any lawyers that are handling this, and we refer to a firm out of Houston for it. It's extremely specialized, though, and it's not as easy as they make it seem. So let's say, you know, you wait your time, you get your residency, great. You know, you're now a legal resident. Our advice is file for citizenship. The minute you qualify, you need to file for naturalization. Why? Because once you're a naturalized American, you can do whatever the hell you want and you're not gonna lose your citizenship. You know, but until you get to that point, then you need to be careful. You know, if you don't have papers, then you need to live a very, very, very clean life in the United States. Once you're a resident, you know, the law will allow you some leeway, and if you make certain mistakes, then you might have certain waivers available to you. But the ones who can pretty much, you know, do what they want are the Americans. And until you're an American, you need to live your life like you could lose what you have. So how can you apply for citizenship? 5 years as a resident. You have to be living in the United States for 5 years in order to file for naturalization. If you want to do it in 3 years, it's because that you are living and residing with a United States citizen, the same United States citizen. So when you take the exam, it used to be that, you know, you could just file the application and you're ready to go. Now they actually want proof of 5 years. They want to see proof, your tax return. They want to see proof you don't owe anything to the IRS. They want to see actual documentation that, you know, you've been living in the United States for 5 years. On the 3-year one, they want to see proof, okay, are you living with this American? Let me see. You know, tax returns are a great indicator if you've actually filed them, because it's a federal document that you file. And so, you know, either you've committed fraud with the IRS or you're trying to, you know, commit fraud on immigration. A lot of clients want to know, well, when can I take it in Spanish? You know, I'm already 60 years old, can I take it in Spanish? Once you have 15 years as a resident and you are at least 55 years of age, you can take it in Spanish. If you are 20 years with your residence and you are 50 years of age, you can take it in Spanish. It used to be all you had to show was, this is my age, this is my card, I qualify. I've got the 1555 or the 2050. Now they want proof of those years. You know, you essentially take a packet, it's usually a ream of paper, with all 20 years of proof that you've been living here. We see this a lot because there's people who are residents who've been living in Mexico. And now they're like, well, I've been a resident for 20 years, I want to apply for naturalization. Well, if you can't show that you've been physically living and residing in the United States, then you're going to have to do it in English. And these people do not speak English. So it's something that they've started to require that they didn't used to. Immigration is getting better. I will give them credit on that, because, you know, they're catching things that they should have caught a long time ago. They've caught up. Now, if you file a tax return, you know, we have clients that have a foster child and a niece and a nephew, and you got all these dependents. Immigration wants to say, okay, prove that you provide support. Bring us the bank statements, bring us the checks. They didn't used to ask for that, and now they are. And so clients who are filing returns saying, you know, I've got a foster kid and you haven't been really providing support, you're not going to be able to apply for naturalization. The other thing with naturalization that we've seen is it used to be easier to become a resident. You know, my father's a U.S. citizen, here's this delayed birth certificate, you know, all right, the family comes in. Now you apply for naturalization and you're essentially opening up Pandora's box, because they're going to go back and look, how did you become a resident and who petitioned for you? And is that person really an American, or is there a Mexican birth certificate? And it takes, like, some of them could take a year in investigating. And we will have naturalization applications that come back with denials because they say, well, the petitioner who filed for you back in 1985 has a birth certificate in Mexico, so they're not really a citizen and you were never really a lawful resident, so we're denying your naturalization. This will cause panic to our clients. All immigration can do is say, you know, you're not a resident. What they have to do thereafter is refer your case to the immigration court, and then the judge will decide. And I have a client right now who, I think she's a teacher. She immigrated in 1985. Her U.S. citizen father petitioned for her, her sibling, and her mother. She, on her own, because it's an easy application, goes and files for naturalization. She goes to the interview, and immigration does some checks and finds out that the father actually has a birth certificate in Mexico that predates the one that was filed in the United States. So they put her in proceedings to remove her, to deport her from the United States. The father has a U.S. passport. And so a U.S. passport under current law right now is conclusive evidence of citizenship. And immigration said, well, we don't care. You have a passport, but it doesn't matter to us. Go see the judge. And we're having to fight this case in front of the judge. So she's panic-stricken because she says, what am I going to do? She immigrated in 1985. She's been here before then. She's like, I'm a teacher. I have a child. I don't have a husband who can immigrate me again. What can I do? We kind of fight the case. You kind of deny everything that immigration's alleging. And in her particular case, the government said, you know what? The dad's got a passport, and until the State Department decides to pick it up and revoke it, he is an American, so we're closing the case. So her case got closed. But she's living with that over her head. Because at any given time, if the State Department says, you know what, we doubt he's an American because he's got that Mexican birth certificate, they can revoke that passport. And once they revoke that passport, she's subject to removal again because they know about her. She called attention to herself by filing for naturalization. We will have clients that come into our office that we tell them don't even think of applying for naturalization. On a renewal of your residency, what they're looking for is criminal. When you go to renew your residency card, what they're going to check, have you committed a crime? Have you done something where we can go and take it away from you? With this issue with the delayed birth certificates, the midwife births, they're not really looking at that yet. But if you file for naturalization, well, you're giving them the authority to do that because they're investigating all of that. So, some clients, you can file for naturalization on your own. Our advice is at least go talk to a lawyer. Go pay for the consult, talk to an attorney, not a paralegal, and tell them, look, this is my history. What do you think? Because we will tell clients, do not do it. With your residency, you'll be fine. You cannot petition for anybody, and you cannot naturalize. Because you never know what's going to happen. We've had more than one client come in and they're getting put in proceedings because of something that happened, 20, 30 years ago. So how can you lose it all? Let's say, you don't apply for naturalization, you finally become a resident, and then you're in jeopardy of losing your residency. There's two ways to lose it. There are grounds of inadmissibility and there are grounds of deportability. And all the grounds of inadmissibility are found in Section 212 of the Immigration and Nationality Act. Yeah, and Daniel is an attorney that I work with, and he was kind enough to bring the act. Yeah. This one is not the most recent one. The most recent one, I think, is purple. But thank you. But this is, our little mini Bible. So, and I have it tabbed. So 212 governs all the grounds of inadmissibility. If you want to become a resident, then we need to see, are you admissible or are you inadmissible? Essentially what you're doing is you're asking, the United States, I want to be admitted into the United States. And we pull the book out to say, is there anything that you've done that makes you inadmissible? Once you're here and you're a resident, and if you mess up, then you're deportable. We let you in, you screwed up, and now we want to kick you out. So the grounds of deportability are in 237 of the Act. So there's two separate sections. And we always, depending on what we're going to do, we'll look at 212. If we want somebody to, who wants to immigrate, somebody who says, I'm a citizen and petitioning for my wife, she had a problem. Okay, let's look at 212. Is there anything that she needs a waiver for? Then we'll get the clients come in. I became a resident 12 years ago. 2 years ago, I got arrested, possession of cocaine. That's 237, because those are already here and they're in jeopardy of getting removed. So this is what the definition of a conviction is. And I put the legal definition as defined in the INA because it differs a bit from state law. Under Texas law, if you get deferred adjudication, it is not considered a conviction. Deferred adjudication is essentially them saying, you're going to comply with X, Y, and Z, and then we're going to take away the conviction. It's not going to appear on your record. With the state of Texas, you're fine, but immigration is another animal, and that still counts as a conviction. So we get clients coming in saying, well, no, they told me it's not going to come out on my record, and I paid everything, and I completed. The state of Texas does not have the problem with you. It's immigration, that's federal law, that's got an issue. Because even though you complied, and for purposes of Texas law, you don't have a conviction, immigration still treats it as a conviction. And the law is very clear on that. So basically, it's any judgment of guilt, even if it's been withheld, which is deferred adjudication. You need to be careful with that. So what is not considered a conviction? So far, juvenile courts are not considered conviction. So if you're 14, 15 years old, you get possession of marijuana, if you can get it in a juvenile court, that's a good route to go because it's not considered a conviction. We had a client that we immigrated, and when he was 15 years old, he had a sexual assault, but they treated it in the juvenile court. So he did not need a waiver. He was not inadmissible. He was in. We got him in. And immigration knows, it's a jury conviction. It popped up that he had it, but they could not hold it against him because it was a juvenile conviction. Pretrial diversion. Pretrial diversion is, you pay a lot of fees, you donate some money, and they just kind of, it's not considered a conviction, and it works. So if you can do pretrial diversion, that's one way to go. A conviction that gets vacated because of a constitutional or due process violation. We will get clients that go and get convictions vacated because, 5 years ago, they were down the wrong path, they've seen the light, they're rehabilitated, and they're a good guy. That is not good enough. That's a conviction for immigration purposes. The orders have to say that the constitutional, or what the constitutional violations were, what the due process violations were. So if it does not say that, and it's just that, you found the light and you're a good guy, it's still a conviction. It's still going to come back and affect you for purposes of immigration. So you need to be careful with that as well if you have criminal issues in the past that you want to try and, get rid of. Right now, there's a case that came out of the Supreme Court, that's the Bailia decision. And Bailia, basically, the argument with Bailia was, this guy had been a resident for 40 years. He was a Vietnam vet. He gets arrested for transportation of marijuana. And a lawyer says, don't worry, you've been here a long time, it's not going to affect you. He goes and he pleads guilty. When you've got drug charges, anything after 96 and it's a drug charge, the only waiver is a possession of marijuana. It could be 50 pounds, 60 pounds. We had one that had like 200 and some pounds. Possession of marijuana, you got a waiver. Anything above that, transportation, delivery, conspiracy, you're out. No ifs, ands, or buts, you're out. This guy believed his criminal lawyer, who told him, don't worry about it, even though it's a transportation offense for marijuana. You've been here too long, they're not going to deport you. So he gets convicted, he pleads, gets convicted, immigration picks him up, puts him in removal, and, he realizes, I don't have anything. I'm going to have to leave the United States. I think he was from Honduras. So he files post-conviction. He goes back to the court saying, hey, my criminal lawyer didn't tell me that this was going to affect my paperwork. If I knew that this was going to affect my residency, then I would have fought the charge. I have nothing to lose, He took it up, and they said no. There was no Sixth Amendment violation. The immigration issue is just a collateral consequence. It's not a direct consequence. He took it up to the Supreme Court, and the Supreme Court said no. He's got a right to, the language, because I want to give you the language. It was counsel must inform a client whether his plea carries a risk of deportation. And so it's very clear. Now, do they have to specifically tell you what the immigration consequence is? No, they're criminal lawyers. But at the very least, they need to tell you, go speak to an immigration lawyer. Here in the Valley, the judges have gotten very good in the courthouse here of telling the clients, I'm not going to accept your plea, you need to go talk to an immigration lawyer. And we get criminal attorneys calling us saying, look, I have this guy, this is what they're offering him. What do you think? And so we'll look at it. When it's drug charges, you got any drug charge in federal court and you're essentially out. There's no waiver for you. And so those are easy. Conspiracy, 60 kilos, it's like, no, there's nothing for you. The law is very strict on drug offenses. Pre-96, there was waivers. After 1986, it's very, very limited. So the Supreme Court has said that, when you're going to plead a case, if your criminal lawyer does not advise you, or you don't seek counsel, or they don't advise you at least to go seek counsel with an immigration lawyer, then there are grounds to vacate the conviction. And so that's helped us in some respects because we have a lot of clients who say, look, my lawyer didn't tell me. He told me it wasn't going to affect my paper, that it wasn't going to come out on my record, so I pled. They're going back and they're filing the Padilla motions. And we don't do that. It's a criminal case, and so we refer to criminal lawyers to do that. It won't work in all circumstances, and you still have to have judges willing to say, you know what, I agree. Your lawyer did not advise you correctly. It's not a given that we'll be able to still succeed in immigration court, but at least we've got to fight. Right now, if you've got a transportation of marijuana, you don't have anything to fight. It's not that we don't want to help you. It's just there's nothing under the law that allows us to help you. So what are the common grounds of inadmissibility? You want to become a resident. You want to immigrate to the United States. You want to adjust your status. How can we do that? Well, you already know the family-based petitions. But what if you have certain things in your history and your past that, disqualify you? Health-related grounds. You have to be a drug abuser, a drug addict, in order to be inadmissible. If you admit to abusing drugs, then you're inadmissible. They will not let you in. It used to be that AIDS was also one of these. And it was probably maybe 3 years ago that they removed that. If you had AIDS, you could not become a legal resident of the United States. The United States did not want you. Right now, if you're in the United States, we can work with that. When you go to the consulates abroad, you have to go, when anybody wants to immigrate, you have to go to a medical interview. And you are confiding in your medical doctor. And he's not your personal doctor, but he's a doctor. And, we had a client that went and the doctor is, okay, have you ever smoked marijuana? Oh, yeah, I did it 2 years ago. Because he admitted to smoking it, the consulate said, we're not giving you your residency. You got a drug problem, you need to wait 3 years, you need to go get some therapy. They will treat DWIs like that, where they will make you go and seek counseling, and do therapy before they will allow you to immigrate. It's not really an addict. There's nothing in the record to indicate they're addicts or that they're alcoholics, but the admission is enough. And when you're abroad at the consulate, well, what can we do? You're out of the United States. At least when you're here, we've got some abilities to appeal, to fight. You don't want to decide, send us to the judge. We'll fight it with the judge. But health-related grounds are one of the grounds of inadmissibility. The big one are the crimes involving moral turpitude. What is a crime involving moral turpitude? Well, it doesn't tell you. It's kind of something that, you'll know it when you see it. And so it's somebody who's committed or who admits committing them. And so you don't even need a conviction. If you admit to committing a crime involving moral turpitude, then you're inadmissible. And, there's case law that says they need to know the elements of the offense. If there's an admission, they at least have to be provided the elements of the offense for it to count against them. But, there's one exception. There's two exceptions. If you're, under 18 when you committed the offense, or when you admitted to committing the offense, and it's, 5 years before your application for admission, the big exception is the petty offense exception. And the petty offense exception is essentially your misdemeanors. We get a client that comes in, they don't want to tell us everything. And then it comes out, yeah, I had a shoplifting when I was 16. Okay, did you go to court? Yeah, I went to county court. Okay, it's not a juvenile conviction, you were in county court. They're worried that this means that, I'm out. I'm not going to be able to do anything. Well, no, it's a misdemeanor offense, and so it falls within the petty offense exception. It's a one-shot deal. You get one bite at that apple, so you can't pick up a second one. Petty offense exception is no more than 1 year in jail possible, and you are not sentenced to more than 6 months. And so when we get one that's, okay, yeah, I have one shoplifting. Okay, we can work with that. You get a second one, now you need a waiver. And the problem with waivers with immigration is they're discretionary, and you're essentially leaving it to the authority of the officer interviewing you as to whether or not they want to give it to you. And good luck with that, because they're very difficult to get, at least from immigration here. Controlled substance violations. If you commit a controlled substance violation, you do not need a conviction. And so you have possession of cocaine. Could be under a gram. Possession of cocaine conviction under a gram. You say, but I'm married to a United States citizen, I want to immigrate. We can't do it. There is no waiver for you. The only waiver when you want to become a resident for drugs is 30 grams or less of marijuana. The problem with state law is Texas law says under 2 ounces. Well, how much is that in grams? 2 ounces is over 30 grams. So if you get arrested for possession of marijuana, you need to get that weight in grams. And you need to tell your lawyer, get it in grams. Have the PD weigh it in grams. Because if you want to become a resident, then you have the burden to show you're eligible. The immigration doesn't have to show, no, look, this is what it is. No, you have the burden to show you qualify. And so if you go and you're like possession of marijuana under 2 ounces, and there's nothing to indicate how many grams it was, then we're going to have a problem. Because the immigration law only allows under 30 grams. And it's a waiver situation. You got under 30 grams, you can file a waiver. You can't show under 30 grams, then you're out. And it's only that drug. I had a mother call me she was a United States citizen. She was born here, never lived here, went to Mexico. When her son was 3 years old, she brought him to the United States. He's 18 now. He gets arrested, possession of cocaine under a gram. She doesn't go talk to a lawyer when he's in county to say, look, my son doesn't have papers. He's got an immigration hold. Because if you don't have papers and you get arrested, you're getting an ICE hold. You're not getting out of county. Immigration puts you in the system, and it's like, no. If somebody goes and pays the bond, we get them first. So she doesn't go and talk to a lawyer at that point either. And he pleads guilty, possession of cocaine under a gram. So after he pleads, he gets credit for time served. Immigration picks him up. They take him to immigration detention. Here, the facility is in Los Fresnos. It's a Port Isabel Detention Center. And she calls saying, what can I do? Our question, did you ever file for him? Did you ever do anything? Did you ever live here before he was born? Nothing. Everything was no, 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 no. So he's 18 years old. How is it possible that in 15 years it never occurred to you to file something for him? And, you know, I went to talk to somebody 5 years ago and they said I couldn't, you know, so she just didn't do anything. She wanted just to give him her citizenship, and she couldn't do that. She didn't qualify. But she could have petitioned for him, you know, U.S. citizen petitioning for a child under 21. It's immediate, and he would have gotten residency. And then we could have gotten him the citizenship, you know, quickly thereafter. But she never did anything. So he's at Port Isabel, and she's frantic, and she's crying. And she's like, well, can I get him out? Drug convictions, after 1998, you're mandatory detention. So if you get detained by immigration and you've got a drug conviction after October of 1998, you are mandatory detention under the law. Meaning, even if you have a waiver, you're fighting for the waiver detained, because the law does not give the immigration judge the authority to issue a bond in your case. Now, this guy, he's got a possession of cocaine, so even though he's 18 and he's still considered immediate, there's no waiver for that. And she's like, well, it's under 30 grams. Yeah, the under 30 grams is marijuana. So even though it's under a gram of cocaine, there's nothing. You know, he's not getting a bond. He's never, ever, ever going to be able to immigrate into the United States unless the law changes, which is not likely. And he's getting deported to a country that he hasn't been to in 15 years. And because this woman sat on her laurels and did not move. You know, it's more anger in those situations, because you really wanted to strangle the parent and say, what the hell were you thinking? You know, like, how could you do that to your child? The problem we see with these kids is, you know, they're brought over as infants, as toddlers, you know, as kids, and they consider themselves United States citizens, and they live their life like they're United States citizens. Now, is this guy a bad guy? No. He made a mistake. You know, he's 18, he made a stupid mistake, he got caught with cocaine at school, and I mean, it might not even have been his, you know, but he wants to be a guy and take the blame, but it screwed him for the rest of his life. And this is a kid that we could have saved if she had come to us a year before to say, you know, I want to file for my kid. Okay, this is what we have to do. We need to hurry up and do it. But she didn't do it. You know, she's in the United States. She's an American. And her son, well, you know, he's got to learn to live his life in Mexico. So when there are controlled substance violations, you need to be very careful. You know, drug paraphernalia, you get caught with some marijuana and a pipe or papers. And they'll tell you, you know, plead to the paraphernalia. It's a misdemeanor. It's not going to affect you. We need to link the paraphernalia to less than 30 grams of marijuana. Because if we can't make that link, then you don't qualify. So sometimes we tell clients, it's better to plead to the possession, because at least we got that in grams. You know, how are we going to link the paraphernalia to under the 30-gram minimum that the law requires for you to be eligible to apply for a waiver? So, you know, get it in grams. If you're going to get, you know, if you're going to do drugs, which I don't recommend as a lawyer, as a member of the bar, you know, I don't recommend you do it, but I understand that, you know, you're kids and you're young and, you know, you don't think. And so if you get arrested with a possession, you know, you need to be like, okay, I already screwed up. It's done. They know I did it. Or, you know, you're going to fight it, but get it in grams. You know, before evidence is destroyed, before it's too late, you tell your lawyer, you need to get it in grams. And we tell the criminal lawyers, get it in grams, get it in grams, get it in grams. Because that's the only way we can fight these. You know, when it's local, the criminal bar here has gone to great lengths to try and become really more aware of the immigration consequences. And they're really doing, you know, we've got police reports that, you know, 0.2 grams. Great, you know. I mean, you don't want to lose everything because of residue, because of, you know, a trace of marijuana, because we can't establish eligibility. So, you know, that's the issue with the controlled substance violations. Multiple criminal convictions. If you've got 2 crimes, then you are inadmissible. If the aggregate sentence to confinement was over a year, 2 or more crimes. Right now for DWIs, you cannot get deported for DWIs. If all you have is DWIs, you know, you're not going to get placed in removal proceedings unless in the aggregate you've been sentenced to over 5 years of confinement. And when you've got like guys who've got, you know, and girls who've got like 6 DWIs, it's like, you know, immigration's going to start adding the time that you've been confined. And if you hit 5 years, you're getting placed in proceedings. And even though it's a DWI and it's not a drug offense and it's not, you know, some assault or anything like that, you know, good luck trying to get the judge give you a waiver when you've got those DWIs. The last thing they want is to give you a waiver saying, we're going to give you a second chance, and then you go out and kill somebody. So even though it's not anything where, I mean, they're felonies and they're serious offenses, you know, you could lose it all, you know, just because out of discretion, even though by itself, it's not enough to do it. In the aggregate, it could get you out. Controlled substance traffickers. This one, no conviction required. If they have a reason to believe you are a drug trafficker, you are inadmissible. And this is, pretty severe because I had a client who was a truck driver. And he was in Mexico, because he works in Mexico. He was coming over to bring a load. All he did was hitch his cab to the truck. And it happened that, he's like, I don't open the truck. I hitch the cab and I go. They seal it, they close it. I don't have access to it. Well, at the port of entry, they realized it was full of drugs. And so, DEA goes to talk to him, the police go talk to him, and they all believe him. He didn't know this thing was full of drugs. So they say, we're not pressing charges. Immigration picks them up and says, well, even though, the federal authorities and the state authorities are not going to charge you, we have a reason to believe you're a drug trafficker, so we're going to hold you, put you in proceedings to deport you. And he doesn't live here. He lives in Mexico. His thing is my visa. This is how I work. I have a visa to enter, to, drive these, shipments in, and I'm about to lose it all. And so we had to fight his case, and we have to present evidence, that there's no criminal charges. There are no state charges. There's no evidence, no record in his history of drug abuse, drug violations. And even though, you would think if he knew about this, the authorities would have done something with him. They let him go. Immigration still decided, well, we're still going to hold you. There was a client out of Brownsville, same thing. They charged him. He took his case to a jury trial, and they acquitted him in a jury trial. He gets detained on a reason to believe. And the immigration judge he got was a very difficult judge who found, yeah, you know what, there is a reason to believe you're a drug trafficker, even though a jury of his peers said no, and there was no other evidence to substantiate the claim other than the reason to believe. So it's very vague, it's very broad, and it can be very dangerous because, how do you dispute something that you didn't do? To sufficiency where the judge will say, okay, yeah, I believe you. With my client here out of Hidalgo, they believed him because the government got on board. I was fortunate enough to get a very good trial attorney on the other end. And I told her, look, this is his job. These are his bank statements. He doesn't have a lot of money. It's a simple life that he has. And she agreed to terminate. And she was kind enough to terminate with prejudice, meaning that the government can never come back and charge him with that in the future, which was, in retrospect, was a good thing for me. I threw it out there not thinking she would bite, and she said, all right, we'll do it. But this guy was detained 2 months, and he was detained 2 months. At that time, the camp was in Raymondville, and he told his kids, oh, I'm on a trip, and I'm on a trip. So when he gets released, and this is just as an aside, he gets released, he is on his way back to Reynosa. And they stopped at a store and bought all these little toys and knickknacks because his kids believed he was on a trip the entire time. So he needed to show up with, his souvenirs. And so he just stopped and bought a bunch of things because he was so humiliated by the experience. He didn't want his children to know what had happened, And he was fortunate that when we had trial, all the truck drivers that he worked with came. They had to come at 6 a.m. to be at the court by 9, and they were all willing to testify. We never got to that point because fortunately the government agreed with our position and they were able to terminate. But he was in jeopardy of getting labeled a drug trafficker, notwithstanding the fact that the state and the federal authorities said, no, we don't believe you are. Prostitution, another ground of inadmissibility. You think, well, when am I going to see somebody who's got a prostitution offense, come into my office wanting to immigrate? Well, we just had one. And this girl comes in, she's married to a United States citizen, and we're like, okay, is it a real marriage? Because we got to prove it's a bona fide marriage. And, we believe, yeah, it's a real marriage. And we say, any criminal history? And she tells us, yeah, okay. I was arrested for being an escort without a license. I said, okay, well, you had to be somewhere in Nevada. She was in Vegas because, that's, prostitution's legal there. And so I said, what happens? Well, the charges got dismissed. Are you sure they got dismissed? They got dismissed. So we get the disposition saying, there's an arrest because it's going to pop up with your print. Everything you've done will pop up with your print. And so this, well, I used a different name, is not going to fly anymore. Immigration has gotten more sophisticated and they actually check your fingerprints. So, she says it's been dismissed. We get the disposition. Sure enough, it's been dismissed. We're ready to go. Straight case. She has a legal entry. She's got a U.S. citizen husband. She has an arrest. The case got dismissed. We're good to go. We go to the interview, and the officer asks her husband to step outside. And I'm like, this is not good. And she asked her, have you ever been arrested, for prostitution? And she's like, well, that time in Vegas, but it got dismissed because I didn't do it. Okay. She's like, are you sure? And when the officer's already asking you 2 or 3 times the same question, they got you. Just cop to it at that point. And she says, you were never in Tennessee. And her color changes. I was like, oh. So apparently she was in Tennessee. She got arrested for prostitution, and that case was open. Now, had we known that in advance, we would have told her, you need to fix that first before we file you with immigration. Because if you've got a prostitution conviction, you are inadmissible. Meaning that not only are you not going to get your residency, they're going to put you in proceedings to deport you from the United States. And what we did is we threw you in the lion's den. Had you been honest with me, I would have told you, let's just wait. Let's get it fixed, and once we get the dismissal or whatever, we'll proceed forward. So at that point, we're on defense, and our backs are up against the wall. And she was able to get it disposed of like 2 weeks ago. So she should be fine. But prostitution is a ground of inadmissibility. And even though it's something it's embarrassing, and she was embarrassed by it, and that's why she didn't tell us, it's something that we still need to know. Aliens involved in criminal activity who have asserted immunity from prosecution. I've never seen that, and I don't really even know what that means. I guess I'll know it when I see it. But if you've got that or you've been that, you're inadmissible. Significant traffickers in persons. These, are your smugglers, your aiding and abetting, you're transporting. You don't need the conviction if they have a reason to believe you've done it. And so immigration you don't need to have the actual conviction and the adjudication of guilt. If there's a suspicion, it's enough to just, disqualify you. And, this one is one where if you've gotten arrested and it's transporting and it's a misdemeanor offense and, you paid and everything, well, you're out, because there's no waiver for that. Unless the people you were aiding and abetting are your spouse, your children, or your parents. So that you were like trying to cross your nephew over to help your sister out, or, a brother or sister, well, there's no waiver for that. And we see that a lot. And, we can't really do anything with that. So if you've got this where you've been accused of trafficking in people, where you've been accused of aiding and abetting, then we need to know in advance, and we need to know before you plead. Because the benefit of knowing before the plea is that we try to negotiate and talk to your criminal attorney saying, look, what about this and what about this? And we try to find a charge that you can plead to that won't disqualify you from being able to immigrate. Money laundering. Money laundering in excess, I think it's of $10,000, and you're out. And you see this. You would think, we're never going to see this, but we have seen this. Security-related grounds, one of the things they ask you, are you a terrorist? Have you ever assisted in terrorist activities? And, have you ever served in the military, abroad? They'll want to know all of that to see if maybe one of the services that you've done will disqualify you from eligibility. The big one, misrepresentation or false claim to citizenship. You cannot ever say you're an American if you are not an American. Because if you get caught, you're out for the rest of your life. Saying you're a United States citizen when you are not, and getting caught doing it, because the operative words is, getting caught. And you might have as well had a truckload full of cocaine, the same punishment. You're never going to be able to immigrate. It doesn't matter if you have a spouse, if you have children, your brothers, your sisters, you're out. The law is very unforgiving with that. And when you've got kids that, have been here their whole lives, who speak perfect English, it's easy for them and their friends to say, let's all go up to San Antonio at the checkpoint, I'll just say I'm an American. If you get caught saying you're an American at the checkpoint and they realize you're not, and they document it, and they will, then you're out. And this happens more often than you think. We had a client who tried coming in from Hidalgo when she was 9 years old. And she was with her sister, who was 15 at the time. And at that point in time, all you had to do was say yes or no. It used to be that they would just ask you, U.S. citizen? You would say yes. And that's what they did to this 9-year-old. U.S. citizen? She said yes. And they detained her. We filed her residency because she qualified through her mother. We filed it, and right before the interview, she tells me, well, what about that issue I had at the port of entry? And I thought, what issue at the port of entry? And she tells me, well, it's because, remember I told you that in 1999, I tried to come in saying I was an American. And, we didn't have anything in the file indicating that. I said, look, you were 9 years old. The probability of them registering that, I would think, is low. We're just going to go and we're going to see what happens. Well, they had it. They took her prints and they took her photo and they showed us her little 9-year-old photo in the file, and immigration said, no, we're not going to let you become a resident. And I told the officer, she was 9 years old. How can she even have, any sort of knowledge as to whether she's in Mexico, whether she's in Honduras? I told him, the bridge in Hidalgo, I mean, how do you don't even know where the hell you're at. I mean, it's all the same. It's just a blur. I said she was 9. Her mom wasn't there. They didn't call her parents. They just told her, photos, fingerprints, and back to Mexico. They sent her 9-year-old self back to Mexico. And it comes up, in 2009. And so immigration said, no, we're denying you your residency because you have a false claim to citizenship. We took that up on appeal, and her appeal took a little bit over a year, about a year and a half, almost 2. And they come back on appeal saying, because of her age, we doubt whether or not she can be held to that violation. And we're asking immigration to look at this again and see if maybe she's eligible for the for the residency. All they did was send back that decision. The appeals office sent back that decision to the Harlingen office, and Harlingen, within 2 weeks, issued her residency card. But she's 9. She was with her sister, who was 15 at the time, and I'm in the process of trying to get her sister in. Now, her sister's 15, so it's like, it's going to be a little bit more difficult. And I told her, more than likely, it's going to be a case that we have to take to court and try and get you to change the law in court, because the code allows an exception for this, but it's if you're under 16 when you do it and your parents are citizens and you reasonably believe that you were. I mean, who falls under that? It's very, very limited. There is no exception for age. And so under 14, because usually convictions under 14 don't really affect you, I would have felt more comfortable with her being under 14, but she's 15. She's married to a U.S. citizen. She's got a U.S. citizen daughter. Her mother's a resident. Her siblings are all legal. So we're going to try it, knowing that, more than likely it's going to be an uphill battle, and it's going to be one that's going to take a couple of years to fight. But it's, it's very, very stringent, and it's very unforgiving. And so if, you've in the past tried to pass yourself off as a United States citizen, my advice to you would be to stop. Because if you get caught, you're out. At this point, you're out. We had a client come in, and she was married to a Border Patrol agent. And she had tried to pass herself off as a United States citizen. It was documented. There wasn't anything that we could do. And he comes in saying, help me. I'm losing my job. And he does. You get fired for that. And there was nothing we could do. It's like, what are we going to do? She's not eligible for a waiver. It's not that I don't want to file a waiver. It's that there's no waiver under the law to file for. And, there was nothing we could do. Is you need to wait for the change in the law. And that law is not likely to change, because it used to be that you were waiver eligible. It changed in 96. And so, he lost his job, and the wife stays undocumented. And that's just the way it goes. Did she know that was the ramification of her false claim? No. It's something that we brought to her attention, and it's difficult for them to understand that, how is that possible? I didn't commit a crime. I didn't hurt anybody. It's like, well, because that's what the immigration law says. The smugglers are, the coyotes. You're inadmissible if you have a smuggling conviction, and the international child abductors. We don't really see too much of that. Yes. Yes.
Aliens involved in criminal activity will have a certain immunity from prosecution.
Mm-hmm.
Do you think that the children of persons of diplomatic commissions
Yeah.
in the country, if they commit crime, they sort of seek immunity?
Yeah. Yeah, and those children in the future, if they want to immigrate, that they would be inadmissible on those grounds.
Another question. You said that if a person has committed a crime, something like that, happens to be below 14, well, the person who's doing it, of course, some immunity can be given. But at the same time, if the person has committed a serious crime, the case may go to criminal.
Yes, and it's a judgment call on the part of the DA as to whether or not they want to try the child as an adult. I mean, we've got kids right now all throughout the United States. You've got 10-year-olds, 11-year-olds getting charged as adults for murders. The particular client that I spoke of, I think he was 14 or 13 when he was accused of a sexual assault. And he was processed under the juvenile court. Had he been tried as an adult, then he would have been inadmissible, notwithstanding his age. Yeah. Yeah, because, we get clients who know, well, I was a child, I was 17. It's like, well, 17, you're an adult in the state of Texas, and they want to treat you like that. And so even though you're under 18, you're still inadmissible for purposes of immigration. So, yeah. So once you're a resident, how can you get deported? It's quite easy. So aliens who were inadmissible at the time of entry. Right now, immigration has gotten very good and very thorough. And so they're doing all their research and checking everything and finding out that, oh, when we gave you your residency in 1992, you really were not eligible for it. And even though we discovered it 20 years later, we're rectifying our mistake and we're putting you in proceedings to take away your residency. So if you were inadmissible at the time of entry and you lied, because it used to be easy, you would just say, oh, yeah, I'm single, you're married. And so you get your residency and you weren't eligible for it because, you were already a married child. Right now is when they're finding it. And usually they find it because the person goes and applies for naturalization. And so the people forget that, 20 years ago, I told you I was single and I wasn't, and here's my marriage certificate, and they're lining up all the dots, and, they're putting you in proceedings saying you were inadmissible at the time of entry. Smugglers, again, if you have a smuggling conviction, even without a conviction, reason to believe you're a smuggler, you're out. They'll put you in proceedings. Marriage fraud. If you've committed marriage fraud, then you are removable. They will put you in proceedings saying, that you committed that it wasn't a bona fide marriage and you committed a fraud on immigration. And the marriage fraud issue will come up sometimes because you've got scorned spouses who will write in letters to immigration saying, he paid me X amount of dollars, or it wasn't a real marriage and he just wanted me to fix his papers and then he left me. If that comes to the attention of immigration, then yeah, you're removable for that. So now you're in a position where you're having to fight to keep your residency. 2 or more crimes involving moral turpitude. We've got clients that have assault, domestic violence. They've got 2 convictions. They could have been deferred. It could have been that you got probation. If you got 2 or more CIMTs, which are the crimes involving moral turpitude, then you're going to have to ask for a waiver. Right now, possessions, 2 simple possessions, marijuana, personal use, you're going to have to ask for a waiver. So you get a one-shot deal with a petty offense, but if you've got 2, then you're going to get put in proceedings. That's not to say that you're not waiver eligible. It's just, anytime you file a waiver, it's at the discretion of the immigration judge as to whether or not they're going to grant it to you. And you've got the government on the other side arguing that they shouldn't and that you should lose it all and get deported. So those are the 2 IMTs. The controlled substance convictions, with the exception of 30 grams or less of marijuana. So if you are a resident and you get arrested for possession of marijuana, you want it in grams, because if you can prove it's under 30 grams, then they can't put you in proceedings to take away your residency for it. But when you can't prove it, well, this is the difference though. If you want to adjust and become a resident, if you want to legalize your status, the burden is on you to show eligibility. Once you've done that, if the government wants to deport you, then the burden is on them to show that it was over 30 grams. And so, we've got a shifting of the burdens. For purposes of admissibility, we have the burden to show you qualify. But once they want to take it away from you, then the government has to show why they can take it away from you. And so usually we get clients who, they get put in proceedings and they issue a charging document and we deny everything. We deny the conviction, we deny, because then the government has to establish that you've done it. And if the government cannot establish that you've done it, then you are not removable. Records now are readily available, but occasionally they will get stuck and they will have difficulty finding a record or finding the document that they need to show that they can put you in deportation. And so after a few of the back and forth, sometimes we're able to get proceedings terminated. Now we're buying the person time and telling them, you need to hurry up and get everything in order, because once they realize what you've done, you're out. Or at least it gives us time to prepare a waiver. But burdens will shift. Firearms offenses. This with the law is, if you want to become a resident and you have an offense, a conviction for a firearms violation, you're admissible. You can still become a resident. But if you are already a resident and you get a conviction for a firearms offense, you are removable. And so that's, the contradiction in immigration law. I have possession of a firearm, without a license or without a permit. You can still adjust and you'll become a resident, no problem. But if you're a resident and you get that conviction, then you're out. You got to file for a waiver. So, you want to make sure that somebody doesn't gift you something, that you have everything in order, because if they realize that you have it, and the clients that we have who get this conviction will sometimes, get pulled over on a DWI or on a traffic citation, and they find the gun and he doesn't have a permit, and so now you've got this criminal conviction for the firearms violation, and you're going to get put in proceedings for it. So you have to live your life a little bit differently when you're a resident. Domestic violence. There's specific provision in the code for domestic violence. So the convictions here will say assault-FV, family violence. And so if you have a conviction for domestic violence, assault family violence, then you are removable for that. And the burden is on the government to show that it's a domestic violence, a family violence. And so usually we'll deny that, you've got the conviction, and they have to establish, where the violation occurred. And sometimes the record of conviction is not very clear. I had a gentleman at the detention center, we call it the camp, at the detention center who had, a few DWIs, and he had an assault family violence, and I denied that he had the conviction. And the government wasn't able to locate the document that they needed to establish that it was a domestic violence offense. So they ended up releasing him, which was sheer luck on his part, because it was somewhat extraordinary that they couldn't establish the offense, because it was, within the last probably 15 years. But had they done that, then yeah, he would have been facing down the barrel of a waiver. Document fraud. You get caught with any sort of, socials that have been altered, licenses that have been altered, things of that nature, and you're removable for that. Falsely claiming citizenship, you are removable for that once you're a resident. So if you get, sometimes we have residents who, for whatever reason, they don't carry their card, and they think, I'm just going to say I'm an American. If you get detained by, doing that, then you can get put in proceedings for that as well. Voters, if you unlawfully vote, then you are also removable for that offense. And it's one of the questions that they ask you when you go in and you apply for citizenship. Have you ever voted in any election? Have you ever registered to vote in any election? If you're applying for naturalization, it's that you are already a resident. So if you admit to doing that, then they're probably going to put you in front of the judge and say, go ask for a waiver for that. So again, it's one of those things that it would behoove you, even though you can do it on your own, it would behoove you to speak with a lawyer prior to the filing of a naturalization application. Aggravated felonies. This is where the bulk of our clients fall, for having committed aggravated felonies. So here's, it's defined in 101A43. It's a laundry list, and these are the offenses. The obvious ones: rape, murder, sexual abuse of a minor. Sexual abuse of a minor, the conviction does not have to read sexual abuse of a minor. It could read, indecency with a minor. What they'll do is they'll look at the whole record of conviction to see, does it relate to sexual abuse of a minor to, put you in proceedings. If you have aggravated felony convictions, then your relief is severely limited. Residents, a great majority of residents, the waiver that we seek when we're in removal is cancellation of removal. Cancellation of removal is showing that you've been here 7 years prior to the conviction, and that you've at least been a resident for 5 years. And usually the time is not an issue, but you cannot have an aggravated felony. So if your offense falls under one of these, then, the waiver that we use, maybe 85% of the time is no longer viable to us. So we've got to seek other options. Drug traffickers, firearm traffickers, money laundering, fraud. The fraud of the loss of the victim exceeds $10,000. I had a client who applied for naturalization on his own. He went, applied for naturalization, goes to the interview, and at the interview they discover that in California he had been convicted of receiving workman's comp, and he received $17,131 in workman's comp when he wasn't eligible for the benefit. That is a fraud. So at the interview they detain him and they put him in the camp. Not only did they detain him, but now he's got an aggravated felony, and it's like, what waiver do we have? We had no waiver available to us. It would have been something, he didn't know when he pled that it was going to have, those were the repercussions, and he certainly didn't know when he filed for naturalization that this was going to affect him. There's a misconception, but I paid. I served, I paid, I'm out of it. They said it wasn't going to come out on my record. He ended up getting deported. And all because he filed for naturalization without going and speaking to a lawyer first. Had he come, we would have been like, don't even think about doing it. You're going to have issues when you go to renew, because the residencies are renewed every 10 years. But he was one that it was considered a fraud. And because the loss to the government was in excess of 10,000, he was out. Crime of violence. This, I mean, it's a term of art that I think immigration just made up. And it's where there's the use of force or an element of the offense where there's an attempt to use force. Unauthorized use of a motor vehicle is considered a crime of violence because there's a use of force in taking the vehicle. And if you have a crime of violence, there's no waiver for that. And, you know, certain offenses will be considered aggravated felonies and crimes of violence, or crimes involving moral turpitude and a crime of violence. So it's something that when we see that, we've got a problem. Because, you know, what waiver do we have? And usually, you know, we don't have much. Theft or burglaries, where there's a 1-year sentence or more imposed. This is where it's good to get the conviction deferred. The one good thing that remains about deferred adjudication for purposes of immigration law is that there is no imposition of a sentence. Deferred adjudication is considered a conviction, but there is no sentence imposed. And so we will have clients who have burglary of a habitation, deferred adjudication. Okay, we don't have a sentence that has been imposed, so it's not considered an aggravated felony, meaning that we can still apply for a waiver. It's a crime involving moral turpitude, you know, but it's not an aggravated felony and we can apply for a waiver. Deferred is the way to go. If you have to plead, get it deferred. Because there's no imposition of a sentence unless you do not comply with the terms of the deferred adjudication, and what they essentially do is impose the sentence. So, you know, if you get it deferred, you've got to do everything that they ask you to, because if you mess up and, you know, they say, okay, forget your deferred adjudication, we're imposing the sentence that we had initially recommended, then you've got an aggravated felony. Obstruction of justice, another aggravated felony. False documents, also. Smuggling. Failures to appear are considered aggravated felonies. And so, you know, you want to make sure that you comply with everything that you have to do. And even though failure to appear might not seem, you know, a severe charge, it could have great repercussions with your lawful residency status. Any conspiracy or attempt to commit any of the offenses above. So even if you didn't do it and you get arrested for attempt to do, conspiracy to do, it's considered an aggravated felony and you'd be out. I think that's it, yeah. So that's my bio, and my email is on there. If some of you have questions or concerns, you know, you can always feel free to email me, and we could always discuss any matters that way. I know it's difficult to sometimes make their way into the office, but, you know, I'm certainly available via email. You know, I don't have all the answers to the questions, especially when we get into the criminal convictions, because sometimes we'll get a conviction that's like, well, hell, I don't even know what that is. I have to go look at the penal code. It's a lot of back and forth, reading the code. How does the statute read? You know, did you have to do it intentionally? Did you have to do it knowingly? And it's a little bit of research. We encouraged our clients to give our information to their criminal lawyers so we can speak to their criminal lawyers before they plead. And really, there's a lot of good lawyers out there who are doing that. They're being very proactive, and they're seeking the advice of the immigration counsel before they go and plead out their clients. My advice as a general rule, if you do not have documents, you need to live your life very cleanly. Because if you do not have anything that establishes your legal status in the United States and you get pulled over for, you know, rolling a stop, you know, running a red, the police authorities will notify immigration. And it's essentially a traffic citation that's turned into a removal proceeding. And then, you know, they know about you, you're in proceedings, what are we gonna do? So you have to be very, very careful. You know, you don't have to commit a criminal offense to come into the awareness of immigration. Once you're a resident, you need to be careful as well. You know, I have a client who's granted residency, and in 2 years, he's already fighting with his wife. He was having problems. If he commits an assault on her, then he's going to get placed in proceedings. You know, and it might even be a misdemeanor assault, but it's like, we just gave you this and you already messed it up. And so, you know, on a discretionary view, the judges are not likely to say, okay, I will give you a second chance. You know, they're going to say, we just gave you this and you're already getting into criminal problems. So if you're eligible for naturalization, you need to file for naturalization. If you get arrested, you know, and you kind of know you've done it and you're going to have to plead, you know, go speak to a lawyer first. Tell your criminal lawyer. Your criminal lawyer is not going to know the immigration law. And even if they say, oh, yeah, don't worry about it, because there's still some criminal lawyers that do that. You need to be proactive and go seek the advice of an immigration attorney. And you need to seek the advice of many. You know, trust your gut. If you go and you just think, no, you know, I don't really believe this person, or I just think this isn't really right, go speak to another one. Because whatever you do in the criminal court is going to affect your immigration status one way or the other. Now or, you know, 5, 10, 15, 20 years down the line.
Okay, we have about 15 minutes for questions. I will bring the mic to you if you have a question for Ms. Renteria in the time that we have left.
Okay, Ms. Renteria, does this apply only for like Mexican people, or does it apply to everyone in general? Because I've noticed that some people get their residence much quicker than Mexican people.
Yeah.
So can you please tell us a little bit more about that?
Yeah, you know, all of this it's worldwide. You know, immigration does not discriminate. You could be a Mexican that's getting deported, or you can be, you know, a Brit that's getting deported. So you know, it's universal. Some people do get their residency faster because there's just not that many people from that country applying. And so each, you know, every category has a certain amount of visas that are subscribed to that category. And then they're divided amongst all of them. The great majority of people, because of geography, that are willing, you know, wanting to immigrate are from Mexico. The Philippines is very backlogged. China is backlogged. And India. Those, you know, those 4 are the most backlogged countries. So if you get somebody from Germany that's wanting to immigrate, that moves much more quicker. Because there's not a lot of people from Germany wanting to come, but there's a lot of people from India wanting to come, and so that's the reason for the backlog.
I think there's also an immigration issue. Hold on, Vincent. That people from certain European countries are preferred
Yeah.
over here than people from other countries, especially
Well, they're on
from
visa waiver.
Africa
Yeah.
and places like that. I don't know
Yeah.
about Mexico, but you know,
Yeah.
there seems to be some issue there
Yeah.
based on race.
Yes. You know, European countries are on visa waiver. A Mexican wants to come to the United States to visit, they got to go in and get a visa. You know, and you have to show, here are my bank statements, here are my check statements, here's that I have a house. And even like that, they'll say, no, you're denied. And that's it. You know, there's no appeal of a denial of a tourist visa. If you're from one of the European countries, you get visa waiver. So, you know, all you have to do is show your passport, and you're allowed, you know, come in. You know, those people still overstay. You know, and those people still come and break the law. The ones that gain more publicity tend to be, you know, the ones from Mexico. You know, the African countries, Nigeria is a problem. You know, where we see as a matter of practice that if we take a couple and they're of Nigerian ancestry, immigration is going to look at it very suspect. The Israelis are looked at, you know, very suspiciously. Mexicans as well. Indians are also oversubscribed, so it takes a considerable amount of time. But, you know, Germany, France, there's not an abundance of people wanting to come, and they're on visa waivers, so they don't even need a visa. The Italians don't need a visa. Our doors are much more open to certain countries and certain nationalities over others.
Excuse me. Do you know the difference between human traffickers and human smugglers? How this definition is actually
The trafficker, I don't know if I have it defined. Let me see if I actually have it defined. I think the traffickers, as a general rule, you know, their business is trafficking in people, and then the smugglers are just the ones that are kind of bringing them in. You know, I think they all work in concert together, but the exact definition, I don't know if I have it. I might not have the actual definition. I left it in the other. But I can look at it for you if you want to know. Well, the exact difference as far as what the definition is, I'm a little, you know, I don't know it off the top of my head. The similarity is that, you know, being either one will get you removed, you know. So let me see if I have it.
The first one is, you know the law. And is the law really practiced? Are there any political influences involved? And the second one, you know, is also a related question, and that is the election time is coming. And how influential are the politicians in terms of facilitating people to become citizens
Yeah.
because they want votes.
Yeah. I think, we will have clients that get placed in proceedings who go and get a letter from their congressman saying, this is a constituent in my district. He's a good guy. He's done. And that does not make a difference in immigration. Letters from the congressman, letters from the governor, it does not matter for immigration. They just don't care. It would essentially have to be something from the executive branch. And even like that, there's an issue as to whether or not that would have any weight at all in an immigration proceeding. As far as the election, I don't know if there's a great number of people who are advocating for people to apply for naturalization. I know that right now that's the reason that's being given. I want to be able to vote, and that's why I'm filing for naturalization. A straight case will take 4 months, and then the oath ceremony could take another 60 days, depending on how many people are set for any particular ceremony. But I don't know. I know that I'm a member of AILA, which is the Immigration Lawyers Association, and there's always emails, daily emails, weekly emails, and I know that there was a sense of frustration on the part of the administration because nothing had been done about immigration, and it's a frustration that I also shared. It's like, we don't have anything. We're still where we are before. As a matter of fact, what the administration has boasted about is that the removals under this administration have increased, and that they've removed more criminals. And does everybody who's committed a criminal act deserve saving? No. Some people deserve to get deported out of sheer stupidity because they've been given waivers and they've blown it. It's not this, kumbaya type of thing that, everybody deserves to remain here. Some people deserve to get kicked out of the United States. It's simple as that. But, when you've got these backlogs that are, 90,000 deep, 100,000 deep, and this is just from Mexico, and there are people that are willing to come in, who've got the person to bring them in, who are ready to go, and there's just nothing available for them, something has to be done. I don't really believe there should be an amnesty. I think there's a lot of people waiting who are trying to do it right, who need some relief. The amnesty of the 80s, they think the DREAM Act is an amnesty, and it's not. The prosecutorial discretions, which is something that the administration did at the beginning of this year. Prosecutorial discretion has worked very well in the Valley, and it's for people in removal proceedings who don't really have relief available to them, or may have relief, but it's not a good case, and it allows the district counsel, the trial attorneys here in Harlingen, to close their case. And so you essentially get put at the bottom of the list. You're not the priority of the United States government. You're not a criminal. You were a passenger in a vehicle, and they discovered you didn't have papers. So what they do is they admin close that case. It's not terminated, but it's administratively closed, meaning that we're not going to proceed forward at this time with your removal hearing. In other areas, it's not working. They're like, yeah, the Obama administration issued a memo. We're supposed to do it. We're not doing it. Here in the Valley, they're doing it. And so it's working well because we'll have a client who, I have one right now who's a student at Pan Am. He got in a fight with his girlfriend at the island, and it was just a verbal thing, but somebody called the cops. They realized his visa expired in 2004. He overstayed. So he gets detained. He gets put in the camp. He does his own bond paperwork and gets himself out. He doesn't have any parents that are legal. He doesn't have a wife who's legal. He doesn't have children who are legal. And so even though he's been here for 12 years, he doesn't have anything. He is a voluntary departure back to Mexico. This new authority of prosecutorial discretion will allow the government to close his case temporarily. That doesn't mean he's saved. And if in 6 months they decide they're going to revisit all these cases, he could get placed back in active proceedings. But it's something that gives him time, so he can at least try and finish his degree because he's almost done. And in the course, in an ideal world, fall in love. She'll be an American, and he'll be able to immigrate, But it's something that the administration did at the beginning of the year. And prior to that, they really hadn't done anything. So I think they got some favor with that in doing that. The other rule change that they did is the waivers. Right now, if you've got to go through Juarez, you file for your waiver in Juarez. The rule change will allow you to file the waiver here if you're married to a United States citizen. And so that is still in its infancy. We're still waiting to see how restrictive it is, and it is very restrictive. But that's another announcement that they made that should hopefully be implemented towards the end of the year.
Any additional questions? I will take the last one then. Could you talk a little bit about someone who is initially denied admission and then a waiver is filed, they're given admission, and what that process looks like as they apply for citizenship?
Usually if you've already been granted your admission into the United States, the naturalization won't be that big of a hurdle. The hurdle was getting the waiver initially granted. And so, they're not going to make it easy for you. You file for the waiver, the consulate's going to say, no, and you got to wait it out. And so we'll wait a couple of years, 3-4 years, and then we file again. And at this point, it's like, give us all your stubs that you've been living in your country, that you've been working in your country. We'll ask for another waiver, and you get the waiver granted. You come in, you wait 3 years if you're married to an American, or you wait 5 years if you're not. You file for naturalization. They're going to ask you, have you ever been denied a visa? Yes. I applied for a residency in this year, and the American consulate in Ciudad Juarez denied me. It won't affect you because you've already stated it. You stated it in your initial application. You never lied about it. And so as long as you're upfront with it, you won't have a problem for purposes of naturalization. It's when you try to hide things. It used to be easier to hide things from immigration. People say, well, I gave a different name. Okay, well, that worked 20 years ago, but that's not going to fly now. And they're going to realize that 20 years ago, when you became a resident, you forgot to tell them that you have been arrested for, possession. And so it's coming back to get them now. As long as you're honest in your filings, as long as everything is correct and you actually qualify for the benefit, you should be fine. Yeah. Presumably.
The law is criminal friendly here in comparison to other laws in other places.
Yeah.
Other countries.
Yeah.
For instance, having smoking marijuana is more death penalty in Singapore.
Yes. Yeah, that's true. Thailand, Singapore, you don't get a second chance of that. It is somewhat more forgiving. And the waivers that we apply, it's essentially, you telling the judge, okay, yeah, I screwed up. I messed up, shouldn't have done it, I did it, I own it, I'm sorry, I don't do it anymore, I want a second chance. And a cancellation of removal is a one-shot deal. So if you get it at 25, you got a long life to live without having ever, any sort of criminal issues pop up. So those are the clients that we tell them, you know what, you're gonna wait, you're gonna file for naturalization, you need to become an American. Because you doubt whether or not that client's going to be able to live a straight life. And so, you're like, you need to stay clean a while and naturalize. Because that's what we see. Like right now, my partner has been a lawyer for 32 years, and he couldn't be here today because he's out of town, but he immigrated a lot of people in his time. And some of those people are coming back right now because they're getting detained for criminal convictions. And I have one right now who immigrated in 1988 under the amnesty, 92. And in 2007, he got a criminal conviction that renders him removable. And so we're having to file for a waiver. And one of the legal assistants I have handled his case. And his kids are coming in, and they're all concerned, and they're crying, and I go visit him, and he's crying because, we tell him, look, it's a 50-50 deal. The judge wants to give you the waiver, you get it, and if he doesn't, you're out. But, this legal assistant remembers the kids as children, as 4 or 5-year-old, and now they're coming in, they're in their 20s, and they're like, what do we have to do for our father? Because he's one of those that he became a resident 20-some years ago. He made a mistake in 2007, and now he could lose it all. So, there are waivers available, and the treatment that these detainees receive in the United States is much better than the treatment that we would receive in their countries. It's one of the things I remind them of when they're upset that they don't like the food. But, nevertheless, it's difficult. You've got people who committed offenses 15, 20 years ago, and they've changed their lives, and they're having to get detained again in a jail. And when you've made a conscious effort to change your path and, it's all coming back to haunt you, it's difficult for them to deal with that. And they're emotional, and emotions are good because the benefit of an immigration proceeding is you're real. It's a real person in front of the judge. They're real children in front of the judge. It's a real wife in front of the judge, and the tears are real. And so we tell our clients it's good to show emotion. You want to show the judge that what he does and the decision he renders is going to not only impact you, but impact your family. And so, it's still not a guarantee that will, give you a favorable decision, but it's certainly, we're in a better position when all of that is prevalent than when, the clients are acting like they don't care. And for the most part, most of the people at some point realize, I need to care. But yeah, we are forgiving. They've stripped away a lot of the waivers that used to be available, and they've limited the relief available, and more people are excludable now. But, you know, there's still a lot of people that we can help. Okay?
I'd like to ask very quickly that our provost join us up here as we recognize our speaker.
Oh, thank you.
And here's a plaque for your presentation today. Thank you so much.
Thank you. Thank you.
That's great.
Appreciate it.
Round
Thank
of
you.
applause.
Do you want me to hold it up? I'm not. I was like.
And this is also a small token of our
Okay.
appreciation.
Thank you.
Thank you so much.
Thank you, everybody.
Thank you all for coming.
Thank you.
Thank you very much. That was very informative, very informative.
I hope so.
It was, it was, it was.
Yeah.